dog. And it's come over to our house.
So, are we ready?
We're ready.
Okay, so we're going to call this to order. We're going to speak our members. So we have Marcia Greenhouse, Bill DeRosiers, Kathleen Skorka, and me. So that gives us the 4 members we need to make one. Am I missing something, man?
You have a quorum, yes.
We have a quorum.
Quorum, but do you have no alternates you need
We
to?
do have one alternate that could be here, Jeff Ballard, I don't see him. So I will just be honest with you, or if you want to explain that.
You've done this more than I have.
I was chairman for one, he was, anyways, your odds improve the more people you have. So
Right.
We have 5 people tonight, you have better odds of passing this than with 4, because with 4, you actually need all 4 of us to vote
Right.
yes.
Right.
Whereas if you had 5, you get 1 person say no, and 4 people say yes, and you get your way.
So if you wish to proceed.
Well,
knowledge.
Yeah, I guess we should chat about that. Do we have any indications to whether your alternate is going to be?
I tried calling him multiple times tonight, and I got an answer. And then we have another alternate that's in California. No, I'm sorry, she's on vacation somewhere, I'm not sure, and 1 full-time member that's in California, so. We are it. I
Okay,
could try calling the other alternate again.
yeah,
But correct me if I'm wrong. The members can catch up.
they can
By
listen to the
listening to
recording and review the minutes and all the materials. So I suppose we could perhaps move, this is what I would suggest, we move forward with the presentation. Perhaps,
Yeah, I mean, so you're here and
Yeah.
willing to.
Okay, but again, we could delay the vote.
right, we could close the hearing or even leave it open and just delay the vote until there's a full complement of the board. Because as they mentioned, we do need 4 of the 5, regardless of whether there's a quorum. It's not just a majority of who's here. We do 4 of the 5. So it is usually recommended to go forward with a full vote of 5. So, so I would be happy to do the presentation tonight because there might be some open issues that I have to discuss with the town attorney anyway. And then we can decide whether to close or just continue the hearing to the next meeting,
Sure.
when perhaps we could do the vote.
Yeah.
Okay,
Okay, so we're going.
Can I ask a question on that?
Sure.
Does that mean that the vote happens automatically at the next meeting? At the next scheduled meeting, if as long as we have.
No, we have 65 days from today, or you have, the board has 65 days from today to render a decision.
well, 65 days from the close of the public hearing,
Right, 65 days to close the public hearing.
right?
So
And we could keep it open technically, probably for a month.
So I guess my question is, the vote doesn't have to happen in an official.
the vote does not have to happen in March, if that's what you're
It
asking.
has to happen at a regular meeting,
A
but it
regular-
doesn't have to happen necessarily at the next.
I understand, okay, thank you.
You have some time.
Okay, so knowing that, yeah,
Okay.
since what to.
Great,
Okay,
yes, great. Okay, I'll introduce.
If there's something you want me to pull up on the screen, I can.
Well, it's got paper copies in front of them, so if I need something, I'll shout it out, okay?
I might up this stuff.
would you
Okay.
give me your name again? please?
Yes, I was just gonna do that.
Okay.
So I'm attorney Dory Reiser. I'm from Kahan, Krensky, Capicella, law firm in Vernon. I'm a land use attorney. I represent Christine Gomes, the owner of the subject parcel. We have made an application for variances, as you probably saw in the application materials. And the variances would allow the construction of a single family home on a parcel that Christine just recently acquired. It's a 0.43 acre parcel. Now, there would be a contemplated lot line adjustment with an adjacent parcel. The adjacent parcel is at 52. Is Basola Road. And the adjacent parcel is owned by Christine and her husband. It's not, there's no unity of title necessarily here, which is important because there's no formal merger of these 2 lots. Are you familiar with the merger concept?
I did that myself, so,
Okay.
I guess, all right, I'll let you keep going on.
So, and I don't want to like dumb this down too much, but just really briefly, merger is a provision in your zoning regulations that says if you have adjacent land, if you own and same people own adjacent parcels and one of the parcels is non-conforming, then the zoning merges that into the adjacent parcel to make the parcel more conforming. It doesn't really change record title, which is interesting, but it does for zoning purposes say these are gonna be treated as two pieces. We don't have that situation here because, again, 52, which is Basola, which is a conforming lot, which has a house on it, that is owned by Christine and her husband Manny. This parcel, which was more recently acquired to 0.43 acres, is the parcel we're looking for the variances for. That was acquired just by Christine. The fact that they're husband and wife does not change the law, that it is still no unity of title. It has to be the exact same ownership. Because right now, Manny doesn't have any interest in the parcel that's being affected by, even though he's married to the owner, he doesn't have any record title interest in the parcel that's being affected by the variances. So there's the two adjacent parcels. We would like to effectuate a lot line adjustment between the two to make the non-conforming lot, the 0.43 acres that Christine recently acquired, more conforming. And we're gonna get into all of that. I don't know if you recall, I was before you in November of this past year on the Rockefeller application. We talked about this concept of, which was kind of new, something that you weren't that familiar with, this concept of typically for variances, you need a hardship, right? Something unique about the land that takes away topographic, something unique, specific to that land that takes away all useful use if you don't grant the hardship. Grant the variance. Here, there's an exception to that rule, which, you know, again, it's hard to grasp sometimes because it's so drilled into your head. You need to find a hardship. You need to find a hardship. But the Adolphson rule, which we talked about a little bit in November, and I'm going to have to put some more information on the record just because we have to make sure there's a complete record for this, talks about an independent ground for granting variances. You don't need to find a hardship. You just need to prove that you're making a non-conforming use or lot more conforming. Okay, so that's a separate ground. And that's really what we're here to talk about tonight. We've got this variance request to have a variance of the lot size and the lot width, because we still don't have enough land to make it a conforming lot, but we have enough land to make it a more conforming lot. And as you can see from the map that was submitted, you know, the bulk of the land that's being added to it is down by the road frontage. And based on the plan that's been submitted, we can have the engineer to have a house that complies with all of the other zoning requirements with regard to setback. There's no front, rear, or side setback issues. It's really just the lot is still non-conforming from a minimum lot area and a minimum width requirement. So that's the nature of the variances that are before you. Now, the $1 million question for you tonight is was this 0.43 acre lot legally created? Is it a legal non-conforming lot? Because that's what Adolphson applies to. If you have a legal non-conformity, then you can make it, again, more conforming without the finding of a traditional hardship. And so typically, in order to determine if a parcel is a legal non-conforming parcel, you have to go back to the regulations in place when the parcel was created. Did it comply with the regulations or not? So I'm going to give you just a little bit of title back on this property. This parcel, 0.43 acres, was part of land that was acquired by Shirley Bromley in 1951. Okay, she acquired 3 pieces, and they were lots shown on. Do you want to maybe throw up that Andover Lake property plan?
Okay.
Just for a moment.
I can do that.
Bear with 1 second, please.
I've got it, I don't have it. Here we go. Dang.
Super. Okay, so I'm gonna scroll just so you can
Oh,
just
it's
see.
there.
So it, I won't touch the screen, but we're looking down in this quadrant right here. You see where it says 53, 54, 55. Okay, red pointing there. So in 1951, Shirley acquired lots 54 and 55. And the southerly 50 feet of lot 53, okay? The southerly 50 feet of lot 53 is the parcel that's under consideration right now. So she acquired 3 pieces, owned them in 1951, and then in 1954, she sold the neighboring to the 2 of the lots, I should say, 2 of the lots, which is lots 54 and 55, to O'Brien. Okay, I don't know that they're still in the name of O'Brien, but that was in 1954. And she retained for herself just the southerly 50 feet of lot 53. So in 1954, this piece was effectively created as a standalone piece. Okay, so now we have to decide, well, was that legal? Did it comply with the regulations, or was it an illegally created lot? Again, the $1 million question. And I say that because all of the due diligence that we have done, and my client has done a lot. I mean, she hired an attorney to purchase the property. She had a title search done on the property. She acquired title insurance on the property. She evaluated everything that was available to her in order to determine could she use this property. And she found, okay, going back to 1954, this was a piece of land owned by somebody. I should be able to do something with it. So we checked the zoning regulations. Well, what did they say in 1954? Guess what? No one's got a record of the zoning regulations in 1954. The first set of zoning regulations that we can find through the building office or the town clerk's office is 1956. After this parcel was already created. So I am going to go on record to say, I recognize the case law says it is the burden of the landowner and applicant to demonstrate and establish a legal nonconformity, It's our burden. In this instance, because of the town's failure to have adequate records back to 1950, when zoning was first adopted, it is nearly impossible for us to do that. The only way we can do it is through inference, okay? So we are doing everything a reasonable due diligent landowner could do to try and establish this. And because we couldn't definitively establish it, we came to you and said, we need your assistance on this variance. Because in 1956, the regulations did say that the zone requires a 40,000 square foot zone and 200 feet of lot width, which clearly this parcel doesn't have. Again, that postdates when the parcel was created as a 0.43 acres. When it was created, you can see from this map, it's about 50 feet along the road. It's about 370 feet in depth. Okay, so 1956, the regulations say you need this minimum lot area and you need this minimum lot width. It also goes on to say, though, in those regulations that if you don't have that lot area and lot width, so on smaller lots, you can still build a permitted use on it as long as you comply with all the other regulations and you don't own adjacent land. Well, we know Shirley Riley didn't own adjacent land in 1956 because she had already conveyed it away. Okay, and we know now that we can build a lot on this without violating the other setbacks because you have a site plan that demonstrates that with this lot line adjustment. Okay, so the quandary is, if we can establish to your satisfaction that this is a legal non-conforming use, then the case law is very clear under Adolphson that I don't need to prove, the applicant doesn't need to prove a traditional hardship. We just need to demonstrate a reduction in nonconformities. And that reduction in nonconformities is going from a lot that has 50 feet of width to 80 feet of width. And it's going from a lot that's only 18,700 square feet in size to just over 25,000 square feet in size. You can see that on the zoning table on the map that's in front of you. So I think I hope there's no question that this lot is becoming more conforming with the regulations. The only question is, does Adolphson apply? Because is this illegal, non-conforming lot? So let's talk a little bit about that. Again, 1956 is the first version that we're able to find through the town's records of the zoning regulations. And in that, it does reference in 1956 that there was a public hearing held to amend the zoning regulations. So it certainly contemplates that there were regulations in place, okay? And your zoning regulations right now, for purposes of establishing a non-conforming use, say zoning started in 1950. This it seems to contemplate that, yes, there were zoning regs in 1950 and they were amended in 51 and maybe in 52 too. And then here we have 1956. But again, penalizing the applicant for not being able to track down town records that town can't even track down is a hard stretch. So based on all that, and what I'm going to give you for inferential information, I'm hoping we will start with the premise that, you know what, there's enough there in fairness to conclude that this is a legal non-conforming lot, and therefore this Adolphson can apply. So again, in 1956, there was a public hearing held that contemplated repealing a section of the zoning regulations. And you have these, I think, in your packet. Wait, didn't you pass out the zoning regs in your packet? So I'm reading from documentation that your agent had prepared and shared with all of you, and I found also in the town clerk's office. This section repealed, it says Article 3, Zone A, Section 4. And the reason I'm talking about that is because I think from this we can conclude that Zone A is probably the relevant section that applied to this parcel at the time, because here it talks about how they're going to measure the setbacks 25 feet from the high, I'm sorry, 50 feet from the high water line of Andover Lake. So again, all I can do to connect the dots is come up with some inferences as to what might it have been in 1954. So I'm thinking Zone A, if we're talking about setbacks from Andover Lake, that's probably the zone that would have applied to this parcel. It goes on in this section to talk about they're repealing Section 7. Okay, repealing and adopting in its place a regulation that says that the minimum lot area will be 1 acre with a minimum width of 200 feet. So I'm going to pause there. It says more, but I'm going to pause for a minute. So to me, they're saying, okay, if in 1956 we're repealing whatever it previously said and establishing this minimum lot area and width, I'm thinking it either wasn't established before or it was different. Otherwise, why repeal it? Again, all I can do is make reasonable inferences because nobody has these darn regulations to know for sure. But if they're repealing it and adopting a minimum lot area and width, it would stand to reason it's different than what was previous. This section then goes on to also what's being replaced says, but a dwelling may be erected in this zone on a lot having an area or width less than that required in the regulations, provided that such lot has been duly recorded by deed prior to the date of this regulation and all the other regulation requirements are met with. To me, again, by inference, that contemplates that there could have been a smaller lot requirement in place before then. Because if they're talking about if you have a smaller lot, you can still build on it, they must have had some reason to believe there could be smaller lots in the area. Again, I wish I could sit here and definitively say this is a lot of record because there's no question clearly when it was created in 1954, it complied with the regulations. But I can't, and I'm honest with you. I'm being as honest as I can with you. But I think that based on the lack of town records, based on how the revisions came about in 1956, a reasonable person could conclude that either this minimum lot area and width initially came into place in 1956 when this was adopted, or it was something different and perhaps lesser. Okay, what that lesser might have been, I don't know. I would like to say that again, My client has done whatever due diligence a person can possibly do under the circumstances. We can't create records where they cannot be found. And we do have the burden to prove to you. But really, that burden to prove to you that this is a legal non-conforming lot, our burden is to establish that there's substantial evidence for you to reach your determination. Substantial evidence is there something reasonable and rational in the record before you that can help you make that conclusion? So what I have just explained to you, what I have just said, how I've come to my reasoning, how we've done everything, we're looking at everything, we're looking at the text of what was amended in 1956 to try and back into what might have been there previously. I think under all of these circumstances, it's fair to conclude and start from the premise that in 1954, when this lot was created as a standalone parcel, we should deem it to be a non-conforming lot because we can't prove otherwise. There's absolutely nothing to prove otherwise, and proving definitively that it was is impossible. Okay, but we've done as much due diligence as we can. So with that in mind, I'm gonna bring you just to get it on the record, because again, I know we've already talked about this in a prior context of a hearing, but if we establish to your satisfaction that this is a lot of record, then rather than finding a traditional hardship, an independent basis for granting a variance is a reduction in nonconformities. And if you are able to find that this lot with a lot line adjustment is becoming more conforming with regard to lot area and lot width than it previously was at 50 feet in width and what did I say, in area, 18,000 or so square feet in area. It's becoming more conforming than under Adolphson. The courts have held, it's all the way up through the Connecticut Supreme Court, that a reduction in nonconformities is a valid independent basis for granting a variance.
But it's not in the law that we have to. I just wanna make sure that.
It's not.
There's nothing that says in the law that because we had a reduction in nonconformance that we must approve it. You're
It is,
not saying
it's
that.
still for you to determine, is it consistent with the comprehensive plan?
I understand that.
Yeah,
I
and
understand
is
I'm
it
just
in
saying-
harmony with, you know, the neighborhood and in furtherance of public health and welfare?
Right.
So I think the town attorney would probably say you don't absolutely have to grant it, but it is a independent basis that the courts will uphold if you choose to grant it.
Right.
Okay,
I just wanna make sure that everybody here, because you're giving a lot of legal,
yes,
that they understand, my
Yes.
board members, that it's not binding that we have to approve it. It just means that there is precedent, I guess
There's-
we'd call it.
There's a basis.
There's
yes, it's a
basis.
big, absolutely. So,
And there may also be other reasons to not approve it as well. This is,
well, there may be,
Yeah.
but I think based on the plan, we can tell that we can have a code compliant system, there can be utilities available for it, that it can comply with all the other setbacks. And I wanna talk about harmony with the neighborhood and consistency with the comprehensive plan. So we're talking about increasing a 0.43 acre parcel to 0.57 acres. Does that fit into the neighborhood? Does that work? Is it out of character and whack with what you see going on there? Well, I would submit not significantly by any means, because excuse me, the resulting lot will be 0.57 acres. And when I go on your GIS and I do a survey of the Solar Road and what you've got there, you've got a range, of anywhere from, actually down the road closer to Lake Road, you've got a lot that's 0.035 acres. I'm sorry, 0.35 acres. And that's down at 19 Basola. You've got a 0.4 acre lot at 9 Basola. You've got 0.42 acres at 20 Basola. You've got 0.47 acres at 80 Basola. So you have at least four I just pointed out.
38 is
38 is
0.56.
0.56 acres, yes. So you have five, at least, lots developed upon on the same road within, I mean, none of them are more than 1,200 feet away, that are smaller in size. You also have some that are larger. You have some points, almost 0.8 acres across the street, 0.9 acres across the street. My client's and her husband's remaining land will be 1.7 acres. So you do have some larger lots, but you certainly have some smaller, even smaller than the proposed here. And the house that's being proposed, the footprint on it, obviously would have to comply with setback requirements. So it couldn't be, you know, a McMansion out there, because you wouldn't have space to. So it'll be a house that is similar in size to a lot of what's already existing out there as well. So because it's a comparable use, single family use, because the lot's not askew for what you already have in the area, I think you can make a finding that it's consistent with the comprehensive plan and the character of the surrounding area. We have submitted at least one email and one letter in the record of neighbors who are in support of this application and have no objection, which I think is important. So I think that that's also reflective of being, you know, consistent and in harmony with the neighborhood. I think they've already had it. Do you already have this?
I don't have those letters,
I
no,
didn't see it.
but, that's okay.
Oh,
We can put that in.
okay,
If email it to me, I'll
the
make sure they get.
email, I think you, okay.
These are the neighbors that are
I'm sure they get it.
directly, that would be next to this proposed home, and the neighbor that is directly across from the proposed home. And that would be Melanie Gross and Bill Gold,
You're the chair.
and they are both very supportive of this. You know, they know, we showed them and, you know, where we were thinking and.
Attorney Reiser.
Yes.
Just forward that,
I will, I'm sorry, for some reason, I thought they were packed, but yes,
I
I will.
have copies if somebody would like.
Yeah, we will submit that for the record. So, I mean, I know, I've talked a lot of legalese, that's not necessarily what you are typically hearing, you're used to hearing a lot more hardship kind of arguments, but here, this is really more of a legal issue. Number one, can you reasonably conclude that this was a legal non-conforming lot when created in 1954? And number two, if so, do you feel that it warrants a variance under the Adolph exception because we are making an 18,500 square foot more conforming by bringing it up to 25,118 square feet, and then we're increasing the frontage or the width of the lot from 50 feet to 88 feet. Not compliant, but we submit still more compliant. Questions?
I have a question. So we're talking about, so your presentation is all about what you're claiming is decreasing the nonconformity. But what's the ruling on the nonconformity was in effect created by the proposal to put a house on the lot? So,
Well, but the nonconformity wasn't created by the proposal to put a house on the lot. The nonconformity, irregardless of whether there's a house on the lot, the nonconformity relates to lot size and to lot width. So anything you want to do with this lot, you can't build anything. You can't even put a shed on it. You can't even put a chicken coop on it because it's non-conforming for those purposes. So whether or not you put a house on it, doesn't matter, because the house itself would be fully conforming. The house would comply with front, rear, and side yard setbacks. It would not violate the maximum lot coverage requirement. It's solely, the lot itself is undersized, regardless of whether there's a structure on it. So to use it in any manner, a variance would be required.
would it be possible to say, so there's on the proposal, there's that, you know, rectangle that goes from parcel B to parcel A to make it big enough to meet the setback requirements for the proposed house? Would it be possible to make that larger to make this whole thing conforming?
No, there's not enough land to give from 52 Basola to make this a conforming lot. There's just not enough land to do it. We would, good God, if we
Yeah,
could, we would, there's just not enough land to. In order to meet the minimum lot requirements of 60,000 square feet, we can only give so much from 52 to Sola, which is an existing house on it, which we certainly don't want to make non-conforming. Because it's presently fully conforming. But we can still keep it fully conforming and reduce some area, thereby increasing the lot size of this undersized lot, 0.43 acres.
Okay.
Okay.
Can you talk about the septic system, you said septic system's gonna be on the other lot?
The septic system, as you can see, is in that green hash area there, and not all of it, but on the reserve. I think, hold on a minute.
Just the
Yeah,
reserve.
the whole thing.
Well, it doesn't really.
I think is gonna be on this lot and the reserve perhaps on,
Site plan doesn't show the tank as far as I can see.
isn't that
Well,
square
it
right
says
there?
primary, was that primary?
Primary,
Rectangle says
primary.
That's the primary there?
And
So-
reserve is behind it.
Yeah, okay. So the reason that those would be on the easement on the neighboring parcel is because we did not, again, want to make the neighboring parcel 52 non-compliant. Right now, it's a fully conforming lot, and in order to be conforming, it needs to have 200 feet of lot width and a minimum 60,000 square feet. If we put the septic system on, the title on, on the neighboring piece and included enough of the land so that it was part of parcel B, then parcel A, which is 52, would become non-compliant with regard to lot width. So since parcel B is already non-compliant with regard to lot width at only 50 feet, we figured let's keep the non-compliant lot separate. We can make it more compliant. And even if we put the septic system on parcel B, it wouldn't become fully compliant because we still don't have the 200 feet there.
I'm sorry, do we make the other lot less compliant?
No,
Taking-
52 will stay compliant with all zoning regulations.
Okay.
Minimum lot area, lot width, all setbacks. It will be completely compliant. It will remain unaffected. It'll just be slightly smaller. And that was, again, the overriding goal. I think initially, the surveyor and the engineer and my clients had drawn the map to have the septic system on parcel B. And then when I looked at it, I said, well, guys, if we do that, then we also need a variance just to have our existing house lot. And you don't want to monkey around with that. That's where you live. That's your house lot. We don't want to make that a non-compliant situation. Let's keep that lot protected and compliant and just do what we can to improve the zoning compliance of the adjacent lot.
So, can I, that's correct. So, can you explain the reason why this can't be up here?
I can only, I don't have the engineer here. I don't know if you know the answer.
Elevation. Make it pump. Right. So,
So from the health code perspective, so health department's gonna be a little, obviously, they're gonna look at this. I think their ideal situation would be to have the septic system on the same parcel as the house. But there are exceptions to that, and Mark, our engineer, thought that he'd be able to work with the health department on that. However, if the health department says, no way, no how, you have to relocate that septic system so it's on this lot, then I guess maybe he'll have to do some test holes back there and decide if he can do a pump system back there. But right now, this is a system that,
so
maybe it's the
the health
code.
department has witnessed the perk test and all that good stuff.
Yes.
Yes,
They have not issued a B100A yet, have they?
I know,
We haven't seen it,
so,
so.
I can find out, but I don't think so. Do you know?
There's also an issue with that section. The upper part is all ledge. When I built the house, I had to get it all blasted. So where the ridge line drops, the ledge drops as well. So when they dig the deep hole and perk test, they went down 7 feet, whatever. But up on top, it's, a couple of feet and it's ledge.
I just think the board would be interested in knowing the exact reasons why it has to be that, why it can't
In
be
the
up
back
there.
there, not on that lot.
I think,
So,
We can get answers to that, for purposes of granting or acting on the variance. Again, it's limited to, really, are we making a non-conforming lot more conforming? But, you know, I can certainly inquire and see what the engineer.
so
has to
right
say.
now you own both of those lots.
Right now, Christine owns parcel B,
Yes.
and she and her husband own 52.
But at any point, the other lot could be sold.
Well, right now, in the current configuration, it's just the 40-foot through strip. I guess we could sell that, but then you're gonna have someone else back here at some point saying, in order to do anything with it, we need a variance.
No, the other lot,
No.
if they sell parcel A,
Oh,
then whoever comes into ownership with parcel A.
And someone else is-
Now has someone else's.
On their property.
that can happen via easement. So what I explained to your zoning agent is, we will, if you see fit to grant this variance, we will memorialize the septic easement on the land records. We will, just like you can grant a right to a neighbor to grade onto your property or have a driveway easement on your property, this would be a septic easement on the neighboring property. So this 52 will forever be encumbered in perpetuity by an easement that allows them to maintain and repair, replace as necessary, the septic system within that hashed area. They will not be able to negate that in the future. Cause it'll be a title encumbrance at that point.
So if that happens, it probably will eventually down the road if we don't
Mhm.
forward far enough. What happens if, say, the people in parcel B don't maintain their septic system and they pollute the lot and groundwater in parcel A?
Well, then parcel A 52 would say you are in breach of our easement. The easement will say, we haven't drafted it yet, but it would be a private matter between the two lot owners. It's not the town wouldn't be involved. It's a private matter as to whether or not you're acting beyond the scope of your easement. Typically, this easement would say, I, the owner of parcel A, grant to parcel B an easement over this area shown on the map for purposes of building, installing, maintaining, repairing a septic system and all associated facilities. We'll do that at our sole cost and expense in compliance with all laws and regulations, and we will indemnify you for any loss or harm or damage that's a result of our actions on the property. So if their action, which is actually inaction by doing something, or not doing something to the septic system causes some damage, there would be recourse under the easement for them to bring a civil matter between each other and work out the damages that way.
And again, it can't be transferred because it would make lot A, so that the section that is the septic,
Yeah,
that cannot be transferred in the land transfer because, or in the plot redrawing, because it would eliminate conformity for
It would.
parcel A.
it would. So, I mean, I theoretically, if you wanted to condition your variance and say, oh, you know what, even though it's gonna make A non-conforming there, I'd still rather that design and we'll approve your application for these parcels with the condition that you incorporate the easement area into actually parcel B. But you know, again, it would be a little on the unusual side to make a conforming parcel non-conforming, so that's why we're not presenting it necessarily that way.
So it would be legal for the board to create, essentially allow the creation of a non-conforming lot.
Well, the board can condition a variance, they can put a condition on it that they find is in the public interest, and I guess if they say the public interest is to have the septic system on the parcel being served rather than the adjacent parcel, then they could do that. But in effect, what they created was a nonconformity, but blessed at the same time, because they're granting the variance.
Okay.
It'd be a little unusual. We might, if you're considering going that route, we might want to hold this open and advertise again, just to be clear that the variance would be applicable to 52 and not just this parcel. I would probably just, how is it advertised?
There would essentially be two variants with granted, right?
Right, there would be a variance for this parcel for lot area and size, which I'm not concerned about. I know we advertise for that. I just don't know that we advertise for a variance for 52. So if you're thinking along that road, if we wanna be sure that there's no technical defects. Then maybe we would re-advertise to that end, but again, this is what the current proposal is, we think is the better. More conforming plan, I should say, not better, but more conforming plan.
And could you just show me again exactly where the land from the original house is gonna go to the new lot, exactly where that line is?
This is land from 52 that's
Oh,
going
And they're gonna
to,
take that line and move it out, down south, you call it, or down.
yes.
Oh,
So right now, the existing lot line for the 0.43 acre parcel is this line right here,
Yeah, this is the original.
okay?
And they're gonna come out to here?
No, they're saying go here.
No, everything north of this line
Oh,
is part of
this is
52.
the lot right here,
Yes.
and this is gonna go this way, and
Right,
I
I
see
make it big enough to put this. in.
that's there, and then this is gonna be stop here.
Does that help?
Yeah.
He's got it.
Sorry.
Easy, easy.
There's something at the beginning of your presentation that said, regarding the legality of, so the transferring lots, as long as you don't own adjacent property.
Unity of title, merger, is that what we're talking about? So the zoning provisions have, the zoning regulations have a merger provision in them, and if both parcels were owned in the same way by them jointly, these would be deemed merged from a zoning standpoint. Okay, so they would be deemed one parcel and would have to be used for the zoning regs as one parcel. That only applies if you have unity of title and they're owned the same way. Here we do not, because Manny does not own any interest in the 0.43 acre. That's only in Christine's name. Is that,
Yeah, there was something, about the landowner from 1954 when she sold
oh,
lots 53 and 54 there.
all right, so when
I
she
didn't- I
sold
didn't-
that in 19, maybe I'll just go back to my notes and if something triggers it, just.
Yeah, sure.
So in 1951, Shirley Riley acquired lots 54, 55, and the southerly 50 feet of 53. The southerly 50 feet of 53 is what's at issue here. In 1954, Shirley conveyed off to the O'Briens lots 54 and 55, retaining just that southerly 50 feet. That created that at 1954 as a standalone piece. It wasn't attached to anything else.
Right.
Am I still not where you want to be?
I'm trying to piece together. When 52 came, there was something interesting word wise. I'll go back and watch the recording.
Okay,
Sorry.
that's okay. Yeah, I'm just at this point, I would say what I think the narrow issues before you are. Did I give you enough information to conclude that under the facts and circumstances that exist, we can deem this to be a legal non-conforming lot? Okay, again, those facts and circumstances being it's beyond our control to get the definitive proof you need, and the best we can do is rely on some of these inferences we're making. And also kind of the idea of fairness. I mean, I know that might not be a legal standard, but it's a practical standard here. The town's failure to have full, complete records dating back to when zoning started is really what's putting us in this predicament of not being able to affirm, like, definitively answer this for you. But I hope that there's enough there that under all of these circumstances, you can be comfortable concluding it, because that's step one. Is this a legal non-conforming lot? And if it is, then again, are you comfortable applying the Adelson rule, which says if you're making an existing non-conforming lot more conforming and still complying with, being consistent with a comprehensive plan, then it's a grounds for granting these variances that are requested.
So I have a theoretical fundamental question. If someone buys a non-conforming lot, do they have the right to get a variance to put something on it? So imagine somebody bought that little rectangular lot, independent of anything else. So some third party came in and.
I came along and bought it, I bought parcel B.
Let's say it wasn't them and they didn't have
Right.
land. So if they wanted to come in here and get a variance, first of all, they don't have the argument to say they're making it more conforming, because it's already not.
It's not correct, period.
Right, so they don't have that argument to say, we're making this more conforming. If they didn't own the adjacent land and they just own the 4.43 acres. And I said, okay, first of all, can we design a house that fits on that without any setback? Probably not. So then the only argument is, well, does then I come in for a variance for setbacks? And then what I would be arguing is, if this is a legal non-conforming lot, okay, that predated zoning and was created, I would say, well, failure to grant me a variance would basically, in effect, constitute a taking of my property. It would mean I have zero value because I can't use it for any reasonable purpose. That would be a totally different argument that we would be coming in with.
Sure.
The fact that my client does own the adjacent parcel makes it, I think, more palatable because we can design a compliant house. We just don't have enough land to make it fully compliant from a lot area standpoint. So we can make it more compliant, just not fully compliant. So, and non-conformities are a vested right. If you have a legal non-conformity, it's a vested property right that passes on to subsequent owners. You cannot be deprived of a valid legal non-conformity.
Right, but if someone knowingly buys a non-conforming lot, from what I thought I heard you saying, then the municipality has to grant them.
No,
No.
no.
They'll need a variance, is it not?
They would still need a variance. They would come before you and ask for a variance to do something on that lot. It would be more variances most likely than what we're asking for, because they wouldn't have the additional land. They would probably need setback variances, maybe a coverage variance, who knows what they would need.
Right.
But they would need more variances than what we're asking for. And their argument would be, well, if you don't grant them, you're taking all value from my property. That's a totally different argument, and we're not going there.
Financial hardship isn't a reason for taking all value.
Right, financial hardship isn't, but there's some case law that says if you take all value and leave the land useless, then it might be enough of a financial, but again, we're not going there.
Sure.
So that would be.
Purchased solely for the reason of approaching for the variance, knowing
Right.
it's a non-conforming.
That was my.
Right.
Yeah.
Or you wouldn't have to grant it, but,
Right.
yeah, I'm saying.
It's more than what the others.
No.
Yeah. That's
Yeah,
that day.
I lost count. Yeah, well, it's houses in that area. Yeah, that was our
Yeah.
reason. Yeah.
That's good.
Well, let's make this on, yeah,
I would agree.
and just, if could my client just wanted to tell you a little bit more about the research she did before she bought the property. I alluded to it a bit, but let's just, if you don't mind, just let her
Yeah,
make that statement on the record.
prior to actually even getting the attorney to, and having the title search and doing all of those things, which I was fully ready to do in doing my due diligence. I went on the GIS, sorry, and thank you, and I looked at lot size. And I looked first on my road and I saw right away 3 properties, 9, 19, and 20. That were 40, 35, and 42.42, and I said, this lot is 0.43. So I'm operating not with the knowledge base that all of you have, which I respect very much, and I appreciate my attorneys. But I'm looking at that, and then I walk the lot, the lake, and then I would pull up houses, I would say, that's a little lot, 0.23, 0.27, 0.24. And as you know, I'm sure you're familiar with, and if you pull up the map, you'll see lots of lots around that lake are half the size of the lot I purchased. So then I thought, okay, but I'm going to then even do more of my due diligence and would, in my own mind, I hired an attorney, I got a realtor. I spoke with a woman in Florida who owned the property, the .43, Lynn Desi, she's lovely. And then I even had the title search, and they went all the way as far as they could possibly go, and so I thought, I'm a retired teacher, and I thought, I have done my homework. And so it was a little bit surprising to me, and I was very fortunate to have attorney Dory Reiser come in and help me at this point, so that's kind of just to let you know where I was coming from as a kind of so a layperson who lives around the lake and loves the lake and you know.
Well, I mean, we have a lot of non-conforming lots, you know, that, so those properties on the lake, some of them go back to the 1920s.
Right.
And so things are different now.
Absolutely.
Yeah.
Absolutely. So, but this is where, just to give you a little perspective of, like I said, I don't have the knowledge base that all of you have. You know, having done this and understanding, I'm mentally running to keep up with the language this evening, so I appreciate.
Well, we are too. We try to look important.
Well, you do, you're doing a great job with that, nailed it.
Put out a good show. And I thank you, Dory, for the explanations too, because it does help to have someone come in and obviously lay it all out, just spell it out for us, and so not experts, but I'm sure.
I'd like to ask the attorney, and I guess you consult with your client, if we could keep this hearing open so that we have more time
Yes.
for, this is.
I mean, I would recommend that anyway, because we wanna have a full complement of 5 when you actually vote. It would probably be safer to keep it open so that if that additional member has any questions when it's time to have our final meeting and then vote, we can actually respond. Otherwise, if the public hearing is closed, I can't offer any more information.
And this might be very simplistic, and so forgive my simplicity, but drive up Busola Road.
Yeah.
And we actually staked where we kind of are proposing the houses, which again is kind of up from the neighbors to my, that are here with us tonight. They're to the left of the property, beyond the driveway, and then when you go up the road, you'll see kind of where we staked it out and we're proposing it. And you'll also see that our home, obviously my husband and I live in, is up a driveway. And you can't, when the trees are filled, you can't even see this part. of
Where
our
does the
land.
driveway go for this?
Yeah, I was gonna ask that.
I'm wondering, where is the driveway?
For the proposed
For the,
house,
no, for your existing.
for the existing, it's, I have,
Yes.
probably should be better.
It's not shown on the
No,
site.
you're right, it's not shown on there. Can you maybe draw it with your finger?
Is it to the north of the septic system?
It's about. Side from their property
It would have
line.
to be,
I'm sorry.
it would have to be to the north of the septic system, right? Okay.
Yeah.
To the
Yeah,
right of the,
Yeah, can you
to the right of
Yeah.
the septic
Right.
system, yeah.
Right, it's a long driveway, I guess.
Oh, yeah.
Yeah.
Oh, he's gonna show you.
We live right
where
next
it
door.
is.
so-
Oh.
Residents are.
Where the.
Right, how it comes into here, goes into here.
The only place it could be, I guess,
Ah,
Yeah, with that septic system there, so it comes in like this.
without seeing it on the site plan.
Up here.
Yeah, it's right from here, close,
Oh, here, it's right here.
yeah, right there.
Look,
That's it right there, right up there.
And it just kind of swings
okay,
down.
you see right here?
Yeah.
That's the.
Oh.
Right there.
Oh, okay, it's.
Do you see?
Gotcha, okay.
Right. So if you were to take a drive, and of course the trees are bare right now, but when the trees are full, like that part of our property, when we drive in and we grab our mail, you know, from the lower part of our, you know, the driveway, before we go up the hill, that piece to the left has just been woods, and we don't, in almost 30 years, we haven't used it, we haven't, you know, done anything with it, and it's out of sight, quite honestly. And that whole, it's the higher elevation is where our house is, so it's kind of, I'm visual, so if, you know, I look at it, that's why we had to stake it out. Well, he had to stake it out for me, because I needed to be able to see the proximity, you know, to like your place and to Jill's place and to Melanie's place, and see where we're at.
I've got some pictures of,
Oh, yeah.
Can you tell? Sure, that'd be great.
well, there's,
So that's pictures of the thousand words.
there's the sign.
So that, from the road where the sign is and where the house would be, you can't even see our house.
This is looking up towards 66 Basula. That's 66 Basula's driveway.
And actually, I have a letter of support from Jill Gold, who, lives at
This is again,
66.
this is up the hill. You can barely see this gnome's house in the background there to the right. It's kind of.
You can kind of see the picture.
Yeah, I understand, right?
Yeah,
And there it is.
see, there, you go. Yeah, so you have to really go,
And then there's, on the other side of the telephone pole is her driveway.
yeah. And then beyond the driveway down that way is their house.
So this is from the perspective of what would be the frontage of lot 52, essentially, from up.
Lot 52 is where they live now.
Sorry, from lot 50.
53 is,
So this is from.
This picture is looking at lot 50,
At
at the
50
driveway.
At
for
52
lot
from lot.
From 52, from where that sign is.
That's their driveway.
Or- It's a little up the road from the sign.
Can you go back on the site plan? Can you just tell us, not directly relevant here, but I'm curious, where the septic system is for the existing house?
Yes, it's beyond,
Yeah, it's under-
in the back.
Oh, so it's, say, west of the existing house?
Well, septic system is back here.
Oh,
Yes,
okay.
the tank is like over here and then the septic system is all in the back.
So the driveway was, just the driveway go over that, or, I'm sorry, here.
Oh, sorry, yeah, it's, I was looking at it sideways, so the tank is here, and the septic system is, in the back.
So did you have to blast out a lot of just to make that?
No, it's, so where the house is, it's a couple of feet down, but as you go down this way, it drops. So where the septic system is, they didn't have to do any blasting, the only time I had to do blasting was where the house was and for the underground, service, power service, and where the well is to the house, that has to be all blasted.
Oh,
And
okay.
then where the drop is from here down, here, there's nothing, or it's below 7 feet.
Yeah.
And, where the hill is, it's all ledge. When we were building the house, it was like a quarry, that's all you know, it's just rocks.
So what you're saying is that ledge, like all here, like. in this-
Yeah.
Oh, pretty much follow.
Pretty much, yeah, pretty much here, and then from down below, there's nothing, or it's deep.
Okay.
So it would be a little prohibitive to put that septic system.
Right, it's all ledge up there.
Up here, all ledge.
There's boulders coming out of the ground there, it's all ledge.
Yeah.
And somebody told me years and years ago where the ledge line is, and it just kind of like follows where the hill and kind of swings around where the driveway is, and it just shoots down the road. I forgot who told me, but a long time ago, they knew.
No, that's not.
You blast out a ledge.
But yeah.
Yeah, I wanna know if there's gonna be blasting, because when they blasted for their house, we weren't aware of it. And our foundation and well took a big hit,
Oh. Well,
so we wanna know if there's gonna be blasting for this one.
So the foundation, you wouldn't have to plaster your foundation in
No,
the new house?
no,
No, because
All they
where it's
do-
set, I get this. Yeah, where it's set down way.
So the only
Block
blasting that takes
from
place is
the
if
ledge.
you had to put the septic system on your land.
Up in the back,
That would be the only time you
Yeah.
have to blast.
but for
whereas
this
now-
house, for this septic, no.
okay, so if this moves forward, when will that be known as far as whether, you know, when you get in the ground and start digging?
Well, we've already been told where the, for the ledge line.
Okay.
Yeah, where the ledge line and everything is, so it's not near the ledge. So
So,
I hear you, I appreciate what you say, I appreciate you letting me see how it's just 30.
so according to your knowledge of the land,
Nope.
following this proposed plan would not run into problems with
that's
this,
correct.
That's correct, yes,
but, okay.
yeah, no, I appreciate, that
Yeah,
we could address that, cause that's your concern, I'm glad we could address it, absolutely, valid.
right,
Mhm.
okay.
So if you wanna leave it, the hearing open, if you have other questions, absolutely, we're happy to stay as long as you want and discuss them, but if you wanna leave the hearing open till the
Yeah.
next meeting, then we can
Well,
come back.
that's up to you.
Well, I'm telling you, I'm speaking for, we have no objection to that,
objection.
and I think that's the, best case.
All right, so my question is, does it have to be on the next regular schedule, or can we make a special
You could.
date?
You could do a special.
Okay, my thing is I'm on the Board of Finance also,
Oh.
and I will be at a Board of Finance meeting on the next regularly scheduled.
Which is
March, I have a meeting every single Wednesday night going out,
Oh, that's good.
because we have budget season.
Wow.
Well,
We
that's,
want everybody here, so.
And I wanna be here, so, and you're gonna want all 5 people.
if the board decides it wants to do a special meeting, just
Will
let me
we,
know and I'll make
You'll get
it.
it posted and all that.
Sorry, when is the next regular schedule? Is
March 7. Well,
February.
it's on the
Next one.
so do you want?
February 7th.
February 18th, most
February
likely?
18th?
That's a Wednesday, right?
Yeah,
Yeah.
Yeah, I'll definitely be in.
and I know you wanted to listen. to
Actually, I won't even
the
be here, I'll
report.
be in.
Yes, I'm lucky.
Now that I think about it, that's right.
That'd be a Wednesday night.
So you're not gonna be here, so that's.
So
Gonna be
I'm not
anything
gonna be
that-
here on the regular schedule, so if we can do something in the next.
No, it doesn't have to be. It
I'll
can
be
be
there on
any
the
day.
11th, so if we can do something before the 11th, I guess would be nice.
Well,
All you
let
can
me-
say is you can't guarantee that there's gonna be all of us here.
We have to notice it.
Okay.
Well, what I'm saying is, if we would ask everybody here right
Special
now,
meeting, yeah.
then
I mean, it would be best though to continue, if we could continue this to a date certain would be great. Is there any way we could try?
Well, that'd be up to the
Let's try to
board.
work that
Yeah,
out.
get a
I
date.
like to try and pick a date that we all know
Yeah.
we could do this now,
Yeah,
before February 11th.
And notify an alternate as well.
Well, hopefully, Julie Haverhill would be back in California by then, I think she would be.
Okay.
I'll call her, and then now she'd always get
Or something.
an alternate. Yeah, Joan probably back from vacation by then, and or. Val.
Okay.
So, if we can pick a date now and then try to, confirm Julie Haverhill,
Yeah.
and I think, and or Joan. The only thing is, because the room they're all now kind of brought up on speed on everything we heard tonight.
Watch or.
They can watch that too.
Rec
or-
commissions and.
So if we go beyond a week from today,
Really.
then people who are on vacation are likely to be back.
Our business.
Seems a reasonable.
Reasonable, right? So if you look at either the 28th or the first week of February.
I
So,
cannot do the
um,
Thursday, the.
If I might interject,
It doesn't have to be Wednesday.
Oh, it doesn't have to be a Wednesday, no, sure.
You just need to know that the room's available.
it could be Wednesday, the 4th
Of February.
of February. It could be Thursday, the 5th.
I can't do Thursday.
Could be Friday if you want to meet on Friday.
Yeah, the 4th would be
Friday.
good for me. You said you can't do the 4th, Mark? Sorry.
Actually, yeah, I can't do the, I'm sorry, I cannot do the 4th or the 5th. I apologize. Is Tuesday the 3rd not?
I could do Tuesday, the 3rd.
you guys already have a hearing here in Wetlands on the
I mean, you
third.
could do it at 6 instead of 7.
Yeah, I mean,
Good little while.
Yes.
There works. Is that works 6 o'clock on, Kathleen, on
Gives us
the,
some time frame to move things along.
that was the 3rd at 6 o'clock?
I guess so.
I appreciate it. I'm sorry, I have a 8th grader transitioning up to 9th grade and they have so many things going on. And I apologize,
No.
but I can't miss those.
Been there, done that. I wouldn't miss it either.
I could do the third as long as it doesn't interfere with Wetlands, because I have to be here for Wetlands that night.
Oh, don't.
Well, you'll be here. good,
I'll be
6
here
o'clock.
anyway.
6 o'clock.
So, yeah.
It'll be a long night for you, that's all.
Is an hour long enough?
I would think an hour would be long enough.
It depends.
You'll be here and we're, so it'd be really the questions that Julia would have if she's here or an alternate.
Right. Well, we just have to assume that one of.
Well,
One of those or an alternate would be available.
with all due respect, I would think, the chair probably should reach out to
Yeah.
everybody and say,
Yeah.
the video is posted on YouTube, please review it.
There you go. So we have the 4 of us all confirmed. We have 1 permanent seat and 2 alternates, so I'm sure we can get one of them to be here.
If need be, and, you can't, or if you think it's too tight with Wetlands that night, I could do the second also that Monday. I don't know, if you want to maybe have 2 dates to run by your alternates to see who's.
Yeah,
That's
I
up
can
to
do the
you.
second too.
It's up to you guys, but I'm available that.
Yeah,
Monday.
we're gonna just keep having the same meeting.
Round about. So just in case it was alternate Monday the 2nd. And that could be at 6 or 7.
Alright,
Whatever,
but we're
whatever you.
tentatively for the 3rd,
Let's go with the 3rd right now. She's-
Okay.
We have a
All right.
calendar.
and now we have a backup.
Friday, Tuesday,
Right, I'll take it back. Do you want me to poll the members? Or are you gonna poll the members and?
I'd rather push off on you if you're okay with that.
You have all the eight
I've
emails,
got all the.
right? So if you can send out the poll to everybody for Tuesday, the third,
Right.
6
It is my
o'clock.
responsibility, I'll do it.
Yeah, make sure they know that we're gonna do it.
Yeah, and big letter 6.
Is that, we get just one date?
Let's go with that date.
Cool.
Works for us, thank you.
Thank you.
All right, are we? are you-
That's coming up pretty darn quick. I think we're good to go. If you guys wanna go, we just have to go through the rest of our regular meetings.
Sure, okay.
We'll close.
No,
Oh,
well,
so,
don't close the hearing, just continue
We're
it.
not closing this here, just this part of this hearing. We now open it to the second part of this.
Super,
So,
thank you.
well, thank you guys.
Thank you.
Take care.
Appreciate
Thank
it.
you.
thank you.
Oh, before we go,
Oh, where you go?
does the chair and the board want anything from the two attorneys prior to that meeting
Yeah.
in writing?
February 3rd.
I have suggested to the chair that both attorneys brief the board, provide brief on your position. Provide it in writing, because it's difficult to follow.
That would be helpful if you would be,
Yeah, I mean, I
That's
can
acceptable.
certainly outline the, you know.
Basically,
makes sense, John?
not a legal brief, but a brief
Yeah,
summary of your arguments.
sure.
That'd be great.
And
And you forward it to Wayne, he can send it to all of us.
I'm calling upon my prior experience as a hearing officer. If I'm in this quandary, I
Okay.
punt and that's what my.
Is it normal to ask, well, I guess nothing is normal in any of these, but, as far as the septic easement, would it be acceptable or reasonable? to
Well,
ask-
as
to ask for-
Attorney Reiser stated, I mean, there's easements for driveways and
Yeah,
The town has an easement that gives.
easements for drainage.
Private property.
There's drainage easements from private property or private property.
Yeah.
yeah.
So I would say the answer to that question is no, it's
Oh, okay.
unusual. I don't know, I would use that word.
Okay, yeah, that
I'm saying as far as the reason behind.
would be nice if you have, that'd be great.
Okay,
And I'll make sure Julia gets it.
Jack, maybe we can chat about
Not
that
necessary.
offline and
And,
coordinate.
I don't know, is it of any concern to the board, the language in the easement?
For the drain, the septic. No, I think that Attorney Reiser's statement was accurate, that there's a way to draft an easement that,
Okay.
you know, has teeth in it and, is enforceable and all that sort of.
Okay.
It would be a, whatever, consideration for this board.
Right.
That's the question I'm asking.
Yeah.
No, I don't think that
I
is.
think it is a consideration for our board.
Right, no.
Yeah, that's.
I was just thinking overall, big picture, when I asked the question, but it's not really of our concern. As ZBA, so, okay. Yeah, it doesn't,
Sorry, I'm
it
new here.
doesn't come under our purview. It doesn't really come under.
All right, so you're continuing to a special meeting, tentatively to be held February sixth at 6 P M.
February
February 3rd,
February
Tuesday the 3rd.
Tuesday
At
the
6
third at 6 P M. See?
February 3rd, Tuesday, 6 p.m. All right.
Thank you so much for your time.
Thank
Hey,
you.
thank you.
Thank you, guys.
Awesome. Thanks.
All right.
All right.
Yeah.
No, you're excused.
Yeah, that's all right. This is very interesting.
Very interesting.
I don't know if the rest of these guys have.
They haven't met me. My name's John Bradley. I'm from Halloween Sage. Everyone calls me Jack. I'm here for Mark. In place of Mark France, he couldn't be here tonight, but thank you all. I
Thank you for being here.
read all this stuff and you got a beauty here.
Yeah. It is a beauty.
So will you be with us next time or will?
I don't know, but I certainly will be
I'm gonna be inviting
probably,
somebody to represent the board.
All right, great.
we'll have somebody. Thank you, Chair.
Nice to meet you.
Yeah.
No, likewise. Thank you all.
Thank you.
Yeah. Thank you, Wayne.
So you're called to order, and then we don't need to see members really, okay, because we have a quorum. Then you can ask all of us, if there are additions or changes, public comment, there's nobody from the public here. So we'll just get through that, old business, we don't have any new business, and then, do we have the minutes from the last
Wayne sent them out to us.
I have a copy here, if somebody
I'd
wants.
love to see a copy of the next, I did not review them. Oh, I wasn't here, so I have scanned anyways. Anybody want a copy of the minutes?
I have it.
You have it? You have it? I was not here, so.
Okay, so let me,
You can vote on that.
let's mark this, any additions or changes to the agenda, folks? Public comments?
No.
Old business, there is none. New business. We've already taken care of that. And so that closes this part of the meeting.
Does the board want any discussion on the new business?
We could discuss it further if you guys want to, I don't think anybody has any thoughts.
Are we allowed to discuss it without the applicant around?
No, you're not allowed to deliberate on this until the public hearing is closed.
Okay.
Public hearing is closed.
Public hearing, it's held open.
No, it's help, you're right, I'm sorry.
Okay, so we can't deliberate on that, okay? So that is done. And so that takes us to, adoption of the November 19th, 2025 minutes. So moving, so Michael moves.
It's on the side.
Seconds.
Yeah,
So,
any discussion?
no discussion on
No
that?
discussion.
All right, so. All in favor?
Aye.
All right, so we approve the minutes.
Abstaining.
Nobody abstained?
I did.
All right. Oh, yeah, Bill abstained. Okay, sorry. So discussion, so our next regular meeting is not February 18th as is listed here.
Oh, no,
Well,
there's next regular meeting, this is a special meeting.
Okay,
So it is still your next regular.
Does that mean we'll have another one?
Yes, you're still, a regular meeting will still occur on the whatever.
18th.
If you have a,
Is there business that we know?
This,
So if we're
it's
not,
gonna be on the third.
if it's not decided on the.
Oh, it's not third, no, they said we just put the bed on
Oh,
the
so this
third.
If you put it to bed on the third, then there may be no
There
business.
may be no business for the 18th, so we don't know. Could still be.
all right. But this is the only thing you have as far as you know this.
Yeah.
Okay, all right. So our next regular meeting, February 18th, our next irregular meeting, special meeting, we've already discussed. So do we have a motion to adjourn?
I make the motion to adjourn.
Bill makes.
I'll
that
take
motion.
that and bring it around again.
Okay, failing any discussion, all in favor? All right.
Do you mind if I take this?
Good job, guys.
Thanks, Wayne.
Thanks.
Thanks for helping us out this way.